This short video is a compilation video of short videos, 1 minute videos I would have made for Instagram. I think there's 4 of them in total, dealing with bringing a claim, all to do with employment law, bringing a claim to the Workplace Relations Commission, the situation in relation to costs, 2P regulations and non-collective redundancy, and the maximum award in an unfair dismissal case. So it's a compilation, as I say, of employment law videos, and you'll see longer videos on my YouTube channel dealing with all of these topics in greater detail. But this is just a sort of a remix or a compilation of short ones. I hope you find it useful. If you do, give it a thumbs up down below, and if you're not already subscribed to my channel, you might be interested in doing so. Thank you. The questions I'm regularly asked in relation to bringing employment claims is about the question of costs. And unlike if you bring a claim or a legal proceedings in court, the winner doesn't take all in employment cases to the WRC or the Labour Court. Each party, whether it's the employer or whether it's the employee, and regardless of whether you win or lose, each party pays their own costs. That's something that you would want to consider if you're considering bringing a claim or defending a claim. As I say, if you went to court and it was a litigation or a personal injury claim or something, then winner takes all. In other words, the loser must pay the cost from both sides. That is not the case in an employment case. In an employment claim to the WRC or indeed to the Labour Court, each party must bear their own costs. You'll see more videos of mine on my YouTube channel, and I think you'll probably find them fairly useful. If you want to submit a claim, a workplace-related complaint, an employment-related claim to the Workplace Relations Commission, just go to workplacerelations.ie, workplacerelations.ie, download the complaint form. There's a standard online complaint form to your computer, and fill it out there, and once you fill it out on your computer, you submit it online, and that's it. You will get a notification or acknowledgement from the Workplace Relations Commission that your complaint, your form, application form, has been received. As you make your way through the form, you just need to be very, very careful that you tick the right box in terms of the right complaint, because you can be blocked or you can be stymied when you go along to the hearing if you've brought a claim under the wrong act or the wrong complaint. So you need to be very, very careful about that and give it consideration. I have a video about this on my YouTube channel. You should have a look at it and check it out. All right. If you're involved in an unfair dismissal claim, the maximum compensation that can be awarded is up to 2 years' salary. 2 years' salary. The employee can also be reinstated or win an order for reinstatement or re-engagement. However, the most common award would be one of compensation. Now, the 2 years' salary is an absolute max, and it's very rare that you'd see anybody winning 2 years' salary, because what you as an employee are entitled to is financial loss. In other words, the loss you've incurred from losing the old job to commencing a new job. So that could be a month, it could be 2 months, it could be 3 months, it could be 6 months of wages that you've missed out on. That essentially is what you're entitled to, your financial loss. You're not entitled to anything for pain and suffering or for embarrassment or for anything of that nature or for disappointment and so on. You can check out more videos of mine on YouTube. If you're an employer and you are going to make somebody redundant, and it's not a collective redundancy, it's a non-collective redundancy, you are obliged to give them at least 2 weeks notice of the redundancy and of the fact that their position is at risk of redundancy. Now, that 2 week period may be longer depending on the length of service of the employee and depending on their contractual notice entitlement. But once you do tell them that their position, give them the notice that their position is at risk, then you should invite their comments or suggestions as to how the redundancy, the dismissal, termination can be avoided. So this is a sort of a consultation period. The employer, however, according to the law, according to the Redundancy Payments Act, is obliged to act reasonably in the circumstances, but otherwise the whole procedure in relation to a non-collective redundancy isn't very strictly prescribed. If you're taking over a business, a small business, for example, a coffee shop or a convenience store, or maybe a supermarket, or indeed any business, a cleaning business perhaps, or if you're going to win a contract or are winning a contract to provide a service like catering or security or cleaning for an institution or a school or something, you need to be very much aware of the transfer of undertakings regulations. 2P regulations is the appropriate regulations which cover this whole area where there's a transfer of an undertaking. Now, it's a very, very complex area. It's a very straightforward matter if you're transferring a business from one person to another. The employees essentially transfer and the terms and conditions of employment transfer with the undertaking. Winning and losing or being awarded a contract is a more complex situation, and you really need to get professional advice on it. If you visit my website, employmentrightsIreland.com, I have a lot of information there about 2P and transfer of undertaking regulations, and it looks at various cases that have arisen